Hello everyone and welcome back to our channel. My name is Ayush Kumar Singh. I am a legal intern in LEXIS and Company. So today we are going to discuss presumption as to dowry death. Presumption as to dowry death is dealt in section 113B of Indian Evidence Act 1872. This act was enacted by Dowry Prohibition Amendment Act 43 of 1986. This section says that when the question is whether a person has committed the dowry death of a woman and it shows that soon after her death such woman has been subjected by such person to cruelty or harassment for or in connection with any demand of dowry, the court shall presume that such person has caused the dowry death. According to this section, two things are needed to be proven in the case there is question with regard to the death of a woman. First, she was subject to the cruelty or harassment soon before her death, and second, that the cruelty and harassment was related to the demand of dowry. Only one case satisfied these two conditions which came under this section. This was said in the case of Bhura Singh versus State. In the case of Om Prakash versus State of UP, it was said that no case are applicable to this section that occur prior to its introduction. In such case, a greater burden lies on the prosecution to prove that the case of the cause of the death was homicidal. Now, what are the essential ingredients for section 113B? The Supreme Court gave basically four ingredients for this section. The first one is the question before the court must be whether an accused has committed the dowry death of a woman. This means that the presumption can be raised only if the accused is being tried for the offense under section 104B of IPC. The woman was subject to cruelty or harassment by her husband or his relatives. Third, such cruelty or harassment was for in connection with any demand of such dowry. And fourth, such cruelty or harassment was soon before her death. Now, what is cruelty or harassment? Cruelty or harassment differs from case to case. It depends on the mindset, so it differs from person to person. Cruelty can be of two types: physical cruelty and mental cruelty. Mental cruelty includes humiliating or ridiculing a woman, putting restrictions on her movement, not allowing her to talk to the outside world, giving threats of her or her near and dear ones, etc. Physical cruelty means actual beating or harming the body of the woman. Every instant of a physical and mental cruelty can put a lasting impact on the woman's mind. If there is any instance where her dignity is harmed, those memories can cause a grave impact on the person's mind. However, in this section, cruelty and harassment is not meant to be a single instant of cruelty or harassment. It generally refers to a course of action sketched over a period of time. Now, what does the term soon before means? The term soon before is not defined anywhere. The section says that cruelty or harassment which has to happen soon before the death of the deceased is the question, only then we can presume that the death was caused due to dowry. The term is related and it is left in the court's distinct how soon is equivalent to soon before. In the case of Keshav Chandra Panda versus State, it was said that the term would be normally implied that the instant should not be much between the concerned cruelty or harassment and the death in question. The cruelty or harassment and the death of the deceased is a question should not be too remote in time so that it can be safely considered that the effect of cruelty or harassment is dispatched. In the case of Kas Raj versus State of Punjab, the deceased was subject to harassment till the time she met her parents. After 2 days, of which she died. In this case, the court held that the harassment that the deceased has faced will be considered as soon before. The second part of this section is, what if a deceased person left a suicide note? In the case of Neeraj Kumar versus State of Haryana, it was written in the suicide note that no one was responsible for her that, and also she wrote that all the doors were closed on her and she has no other way. The court held that when all the available evidences categorically shows that there was a demand of dowry and a ill treatment by the husband and her relatives, then just because it is written on the suicide note that no one was responsible cannot be taken as a conclusive proof that there was in fact, no one responsible. So it's the end, and I hope that you will find the video informative. So please like, share and subscribe. Thank you.